Second time lucky.
This is an appeal in the matter of Roberts and Severn Trent Limited and Severn Trent PLC and others.
May it please the Court. I appear today with Mr. Gregory for the appellant, Mr. Hoskins KC, Miss Mackenzie and Mr. Kennedy, to my right, appear for the respondents. And behind me, Miss Boyd KC and Mr. Cashman are here for Ofwat on the watching brief. By way of housekeeping, we have an agreed timetable for submissions, which is based on broad equality. I aim to finish in the early part of the afternoon, around 2:30 or 2:45 p.m. Although there's really, as the Court will have seen, only one major point, the material's quite dense, and I've discussed with Mr. Hoskins that I may end up needing a bit more time. In that event, perhaps we can take stock at the short adjournment. It may well not be necessary.
Very good.
May I begin with some brief preliminary observations? The legal issue in this case is whether these claims for damages for breach of duty under the Competition Act are excluded by a provision in the Water Industry Act, section 18.8. The tribunal below found they were excluded. I'll examine their reasoning shortly and closely, but there are two immediate framing points that fall to be made at the outset. The first is that the tribunal was clear that if it hadn't found these claims for damages to be excluded, it would have granted collective proceedings orders. This was the key point. And if the Court would kindly please open the judgment immediately in Core Bundle tab 10.
Can we just have paragraph numbers in the judgment rather than page numbers? I think we've all got copies, but it suits us to look at it.
I see. Paragraph 115, which is the last paragraph of the judgment, under the heading conclusion, see that the tribunal said, for the reasons set out above, we find these claims for abuse of dominance in breach of Chapter 2 are excluded by that provision, but if not so excluded, we would have granted a collective proceedings order, CPO, in each set of proceedings. Then if you go back to paragraph 83, which for those using bundle paragraphs bundle pages is page 120, you'll see there that the tribunal found that Professor Carolyn Roberts is well qualified as the consumer representative with extensive and impressive relevant expertise. Second, in the next paragraph 84, it finds the litigation plan effective, and in the next paragraph 85, it finds the litigation funding sound. And then it finds in robust terms that the claims are eligible for collective proceedings. And if you go back to paragraph 113, on that last page, 128, you'll see that the tribunal rejects the respondents' objections and says that it considers the claims clearly suitable for an aggregate award of damages, and they potentially bring significant benefits to class members. As a result of this, if the tribunal is right about section 18.8, its effect is to exclude well-arguable claims on behalf of more than 30 million consumers, which is more than half the adult population of the United Kingdom. That's the first point. The second threshold point is the one which was emphasised in paragraph 17 of our skeleton. After dismissing the respondents' arguments about why they contended the claims were excluded by the statutory provision, namely that Professor Roberts was not relying on an independently actionable breach of duty, the tribunal said it was, the tribunal reaches a decision based on a point that it arrived at by itself, after the hearing and without having heard argument upon it. And it is within that context that we say with respect that Homer has nodded.
Which is the point?
The point is
That it made up.
Well, the point that it made up, I can summarise it in this way. First, the tribunal finds that the acts complained of do give rise to an independently actionable breach of duty. That's the duty under competition law, applicable to dominant undertakings, not to mislead a public authority in such a way as to give them the freedom to exploit their market power to the detriment of consumers. But it then goes on to form the view that because Professor Roberts' case at the loss and damage stage relies on showing that the application of the price control to the companies has been affected by their misleading conduct, that triggers the ouster or exclusion of the damages claim by virtue of section 18.8.
So you say that's actually an activation of the statutory procedure rather than a breach of the statutory procedure.
It is not a breach of the statutory procedure, it's following its consequences.
Yes.
Yes.
Just putting the statutory procedure into effect. There's no breach.
Well, yes. In competition law terms, they've misled the regulator in such a way as to put themselves in the position that they can claim higher prices, charge higher prices to the population. At the causation and loss stage, it is a matter of comparing what was the case based on the information that Ofwat received about the level of pollution incidents with what would have been the case had they received more complete information showing a higher level of spills. And that is an assessment which doesn't require any legal revisiting of the question of
so that's the point they made up in paragraph 41. That's,
yes, and that's what I'm going to come to. It's dealt with, I think, in two main paragraphs, 43 and 49 in the judgment.
Is it 43, not 41? Sorry. Okay.
It's essentially in those two paragraphs. And I'll look at those paragraphs specifically in due course, because it's the task of this court is just to focus precisely on the line of reasoning of the tribunal. But the key point, I can say immediately, that appears to have influenced the tribunal's decision is its understanding of what amounts to an essential ingredient of the competition law claim. This phrase, essential ingredient or essential element, comes from the recent Supreme Court judgment in Manchester Ship Canal 2.
Yes.
The Supreme Court was interpreting the ouster provision in that case, in section 18.8. And what I will hope to show you is that what that phrase, essential ingredient, means is very straightforwardly that there is not another breach of duty, such as misleading the regulator here, on which the claimant is relying to bring its damages claim. And our point is that here, as the tribunal itself has found, there is an independent breach of duty on the facts based on the misleading of the regulator, and because showing the consequential loss of damage is just a matter of establishing how the outcomes under the price control would have been different if fuller information had been provided. The damages part of the assessment does not rely on proving contravention of the licence conditions. Put another way, the claim isn't based on seeking to enforce the regulatory duty to comply with licence conditions. So in a nutshell, that is why we submit that the tribunal was wrong. The respondents oppose the appeal, and they rely on the respondents' notice making 4 points. The route map for my submissions is as follows. First, if I may, I'll show you the shape of the case pleaded on abuse, and I'll take you to our pleaded claim for damages so you can see it. And my central purpose is to show the court that it does not rely on proof of contraventions of licence conditions. It doesn't rely on them at the breach of duty stage, as the tribunal agreed, It doesn't rely on them at the causation stage. After that, I'll invite you, second, to look at the key provisions of the statutory regulation under the Water Industry Act, and we will focus on the central provision, the ouster in section 18.8. Third, I need to look at the critical Supreme Court authority, Manchester Ship Canal 2. And last, I'll go to the reasoning in the judgment itself and look carefully at that short section in which the tribunal's essential reasoning appears, and make concise submissions, or seek to, on it as I do that. I'll deal only lightly with the respondent's notice points that have been raised by Mr. Hoskins. So if I may then, on the first topic, turn to the competition law case, which is pleaded. It draws expressly, before we go to the pleading, on legal principles articulated by the European Court in a case called AstraZeneca. The General Court judgment in that case was handed down in July 2010. The higher court's judgment on appeal was handed down in December 2012. And I'm going to take you first to those judgments, I'll focus on the General Court, to try to establish three propositions. Number one, that the breach of duty under competition law concerns making misleading statements to a public authority by a dominant firm whose effect is to allow the dominant firm to exploit market power.
Sorry, just say that a bit more slowly. Breach of duty under competition
law. It concerns the making of misleading statements to a public authority by a dominant firm, the effect of which is that it allows the dominant firm to exploit market power, ultimately to the detriment of consumers, which is the overriding concern of the competition rules.
To allow dominant firm to exercise market power to the detriment of consumers?
Yes. Second, that's the importance of that case. One of the arguments until that case had been that when you're concerned with the competition rules, you should be looking at behaviour directly in the market, aimed at other companies or other undertakings. Whereas here, what the Commission said as its case, and it was upheld in the appeal, is that if the dominant undertaking misleads a public authority or a regulator in such a way as to manipulate the regulation, to give it the ability then to exercise market power, that can also count as an abuse under the competition rules. The second point is that what amounts to misleading statements will depend on the context. The touchstone for competition law purposes will be to ask whether the false statements were made where their effect has that consequence, that the dominant firm can exercise market power.
Sorry, you say that again as well. What amounts to misleading statements depends on context, but?
It depends on context. So what I mean is, therefore, that it's not every inaccurate statement that will be made to an authority that will necessarily matter. What matters is ones that lead to its ability to exercise the market power. And nor is it necessary, emphasised by the European Court, to show that when it did this, the dominant undertaking had a deliberate purpose of manipulating a system of regulation, or abusing it. Although it adds, if deliberate manipulation does appear on the evidence, that's treated as relevant to a finding of
must have the purpose
liability.
of what? Must have the purpose of what?
It needn't have the purpose, deliberate purpose of manipulating the regulations.
But it must have the purpose of, you said something.
I'm sorry, if I said purpose, it must have the effect
Must have
putting,
the effect.
yes, of putting the dominant undertaking in the position of being able to exert its market power to the detriment of consumers.
Yeah.
And the third point that's made by the European Court is the fact that this duty runs in parallel with, or is coextensive or overlaps with, other regulation governing the conduct in question, doesn't mean that the competition law duty is displaced or deflected. Now, if we turn up AstraZeneca, you find it in the authorities bundles. For those with hard copy, the third authorities bundle at tab 15. And the General Court judgment begins at page 620 of the authorities bundles. And summarise the facts very shortly. AstraZeneca still markets a patented medicine under the brand name Losec, and it reduces stomach acid. The complaint included that AstraZeneca had made misleading representations to the public authorities so as to prolong its statutory monopoly. It achieved supplementary protection certificates, and to keep out generic competitors. And by doing that, it was enabled then to exploit its position and charge high prices for its drug. Now, if you turn over to page 621, I'm looking at the head note, and H3 in this report. You see 3 lines down, the Commission finds that AstraZeneca has abused the position of dominance, this is the Commission's finding, by making representations to the patent offices and national courts as part of an overall strategy involving the supplementary protection certificates, SPCs, to keep generic manufacturers out. The General Court upholds that, and the material paragraphs for the purposes of this appeal are mainly on bundle page 698, and for paragraphs, the first paragraph on that page is 352 under a heading, Findings of the Court, the classification of the behaviour in question as an abuse of dominant position. If you go down to paragraph 355 on that page and you read that, you'll see that that explains that the competition law breach of duty is defined not by submitting misleading information per se, but by submitting misleading information which is liable to lead the public authority into error in such a way as to enable the dominant firm to restrict competition. And in AstraZeneca, the case was that this misleading information enabled the dominant firm to exclude competitors and thereby go on to exploit customers with uncompetitive prices. In our context, the case is that the submission of the misleading information to 2 authorities, the Environment Agency and to Ofwat, had the effect of allowing the dominant undertakings, the sewerage undertakers, directly to charge consumers prices which are unrestrained by actual competitive forces, their statutory monopolies, and unrestrained by the intended proxy in the form of the price control working as it is intended to do. There's no issue on this appeal that the class representative's essential case theory, as I've summarised it, is not arguable, and nor was there an issue as to that below. That's the essential case theory. The second relevant paragraph is right at the bottom of the same page in the report of the judgment, 357. And it begins, the court would point out that the question whether representations made to public authorities for the purpose of improperly obtaining exclusive rights are misleading must be assessed in concreto, and that assessment may vary according to the specific circumstances of each case. And then it explains what it means, what it has in mind. In particular, it's necessary to examine whether, in the light of the context in which the practice in question has been implemented, that practice was such as to lead the public authorities wrongly to create regulatory obstacles to competition, for example, by the unlawful grant of, in that case, exclusive rights to the dominant undertaking. So what they mean here by in concreto is look to see whether in the circumstances this is the effect of the misleading statements that are made. In the present case, the gist of the claim is the proposition that the dominant undertakings have misled both these public authorities in such a way as to result in the sewerage undertakers having scope to exploit their market power as statutory monopolists by charging customers prices above the proxy competitive level which the price control is meant to reflect.
Do we need to unpack what you mean by misled in this case? Because in the AstraZeneca case, it was a clear case of making representations which weren't true.
Yes.
In this case, as you're pleading repeatedly makes the point,
Yes.
there's an underlying obligation to report. So this case is not so much one of giving false information as not complying with an obligation to report, isn't it, fully and accurately? Does that make any difference?
Your Lordship's right to make that observation. In my submission, it doesn't make a difference. It is underreporting in a context where, Your Lordship's right, there is an obligation, and I'll turn to a nuance on this in a moment, but there's an obligation essentially fully and accurately to report. But what they do is underreport systematically and to a very large extent. And by underreporting, they convey a false impression to the public authority of the amount of pollution incidents that have occurred. That then is the material trigger for meaning that they are able to charge higher prices, obtain revenues, and therefore charge higher prices under this price control.
But it might be said that in that very formulation you brought into play the regulations and the license condition, because there's no obligation, there's no freestanding obligation to report. So underreporting is only a problem because they're obliged to report under the license conditions. So does that not bring in the breach of the license condition as an essential part of the cause of action?
My Lord, no. It does run in parallel. It is true that as part of the context or circumstances giving rise to them providing, we would say, false reports, underreporting, there is an obligation in a regulatory sense to provide full and accurate reporting. But the competition law claim focuses on the fact that underreporting has taken place in circumstances where it produces these adverse effects on the essentially the competitive structure, their ability to charge higher prices. And if I may look at that in this way, if one supposes that there is no formal regulatory obligation to provide full and accurate reporting, but the system is nonetheless structured in that way, and Ofwat sets its price control based on obtaining information about pollution incidents and relies informally on this being achieved. So there's no, the regulatory system as it were depends, but there's no contravention of a formal obligation. Still, the competition law point is to say, in circumstances where there is an expectation, albeit not legally binding in that case, that full information will be provided, and where the companies do not do that, and they provide a lower report, which enables them to charge higher prices, therefore, there is a problem. So the competition case relies essentially, one sees from that.
That's not really the question.
It isn't. Just to pursue this a bit more,
Yes.
We're not, the question in this case is not as such whether there's a breach of competition law, it's whether Section 18.8 applies.
Yes.
And just to pursue my Lord's question a little further, you can distinguish AstraZeneca, certainly. It's a very different circumstance of the only reason, frankly, that this information or any information is being provided to the regulator at all is because there is a regulatory obligation to do so. This is not like AstraZeneca, where it was no doubt thought to be in the company's interest to present certain information to patent officers. The starting point,
Yes.
before you get anywhere, the starting point is the regulatory regime, which is the basis or the reason why information is provided to Ofwat, put to one side the Environment Agency at the moment.
Yes.
And we've got to answer the statutory question under section 18.8. So can you, I think I at least need a bit more help on that.
Yes. What I was seeking to show by that example, thought experiment, was simply that the competition law claim would not depend on there being a formal obligation to report to the authorities. Of course, there is a formal obligation to report. Our submission is, and this is the part of the case with which the tribunal was with us, that the formal obligation does provide the context in which the reporting is made. It is made pursuant to those obligations, but the misreporting that takes place, the observation that they provide false and they underreport the number of pollution incidents, as a fact, also has another consequence, because it sounds as a breach of duty for the purpose of the abuse case under competition law.
Yes.
So I'm not saying, of course, that the obligation does not arise under the regulatory regime. It does, and that is the context. But the misreporting, the underreporting that then takes place, independently sounds as a breach of duty for the purpose of competition.
Just to clarify, you are accepting, as I understand it, that the misreporting is also a contravention of the regulatory regime. I understood that to be common ground.
Yes, subject to a nuance that I will return to. I can foreshadow it now very briefly. You're right. When this case was pleaded, in a number of paragraphs, you'll see that in the background section, it said there's a duty fully and accurately to report to the authorities the number of pollution incidents that take place. That was taken as part of the context. The nuance that has arisen, and it may not matter for this case, but should be stated, is that it seems there could be a difference in terms of practical enforcement between the way that Ofwat and the Environment Agency understand enforcing the statute and that pure obligation in the statute itself fully and accurately to report pollution incidents. And to summarise how that occurs, although I can come back to it later, what Ofwat pointed out in its skeleton below, and it's made clear, is that it, when it's requiring reporting to be done for its purposes, falls in behind the Environment Agency. So it requires reporting to be what the Environment Agency has recognised as adequate for its own separate environmental purposes. And secondly, that the Environment Agency itself has said that it was concerned to find underreporting only if the companies are not providing reports based on what they refer to as a common methodology available to all of the companies. It's the way that it saw it. That means, I'm sorry.
Well, I mean, that's all very interesting, but it's not what I think my lord was asking you about and my lady was asking you about. And you can come to it. But what I'm concerned about is assuming the answer to my lady's question is broadly yes. Namely, you accept there was misreporting in breach of a statutory regulatory regime. Then the question is, we surely accept that the essential competition law cause of action includes an allegation which is the same or substantively the same as the breach of the regulatory regime. The question then turns to the proper meaning of section 18.8 and the proper understanding of the term essential ingredient, if that is a term of art beyond the statute, which I wonder about.
Yes.
But what I would like to know in words of one syllable is why it doesn't matter that an essential part of your cause of action is the same as a breach of duty, and yet section 18 doesn't bite.
Yes. Well, we'll look...
I mean, because I understand you had the support of the CAT, but that doesn't necessarily mean they're right. There's a respondent's notice.
No. The first point is that we will turn to the relevant wording in section 18.8, which essentially...
Yes, you must have a sort of bull point. What's your bull point?
Well, it's that the misreporting on which we rely, even if it is coextensive with or arises from the statutory obligation, nonetheless constitutes, for competition law purposes, an independently actionable breach of duty, even in those circumstances.
Right, so then it turns on the meaning of the word constitutes, an act or omission which constitutes.
Yeah, yes, and the final words of section 18.8, which we're going to come to, which have a saving for when the ouster doesn't apply.
Yeah.
So,
Sorry, can I just pick up on that last point? Because your answer was the misreporting, even if only arising from a statutory obligation, nevertheless constitutes an independently actionable breach of duty. You were very careful earlier on, and I think rightly so, not to say
yes,
the competition law claim is made on the basis of misleading the regulator. It's made upon misleading the regulator in circumstances which will have the effect, or likely to have the effect, of enabling the water company to charge more to its customers.
yes.
Is it relevant to the analysis that the misleading part of your case has no legal relevance in itself? It has to be combined with that latter part of the test. And its legal relevance is only because the regulator depends upon accurate reporting pursuant to the licence obligation. So the licence obligation and its breach comes in at that stage, namely it's only a legally relevant thing that they mislead or underreport because it feeds into a regulatory system where the regulator depends upon accurate reporting.
Yes,
the license
yes, that is correct. Yes. So just to step back from this debate, I'm not seeking to say that you can forget about the statutory regime. It is in the context of the statutory regime that they do provide the information. It is because of the way that the statutory regime operates, to follow my Lord's point, that the loss is suffered, and therefore the case does concern the price control regime. Yes. To come to the final point in the tribunal's reasoning that I'm going to address at the end of these submissions, you will see that in the paragraphs that we criticise, the tribunal's essential concern appears to be that the competition case requires consideration of the price control regime, and the price control regime is integral to that case, as it explains. Our point is that by looking at the matter in that way, the tribunal lost sight of the wording of section 18.8, which asks a more narrow question, which is whether contravention of the licence obligation, as opposed to the operation of the regime and how it affects the case, contravention of it and proving the contravention is an essential element of the case, in the sense that there isn't another breach of duty to which the claimant can appeal running in parallel. And our point is that there is in this case. So if I may, that's the first of the, I think the 3 paragraphs I wanted to show you in AstraZeneca. We were looking at paragraph 357 and talking about that. And there I was pointing out that the gist of our case is the proposition that dominant undertakings have misled both of these 2 public authorities, in relation to one of which, and we say it should not be forgotten, the Environment Agency. Section 18.8 has no writ at all. It's simply not relevant, in such a way as to result in the undertakers having the scope to exploit market power. If you go to paragraph 359, in the middle of that page, there you see the point made that it isn't necessary, at least for competition law purposes, to show that these companies intended to mislead the public authorities and reap financial rewards. But if the evidence on disclosure reveals that there was gaming of the system, that can be taken into account on the issue of liability. And the last relevant paragraph to look at is 366, which is at the foot of page 700. There, and I'm reading from 4 lines down, the court said, where behaviour falls within the scope of the competition rules, so that's the first primary question for them, those rules apply irrespective of whether that behaviour may also be caught by other rules of national origin or otherwise, which pursue separate objectives. And similarly, the existence of remedies specific, in that case, to the patent system, is not capable of altering the conditions of application of the prohibitions which are laid down in competition law.
Can we just pause on the separate objectives point? Because another question that I think it would be helpful to explore is this. You could say the whole point of the Ofwat pricing mechanism and requiring reporting and so on is to prevent exploitation of the monopoly position by imposing price controls. Isn't that a very similar objective to the competition claim? So this, again, is rather different to AstraZeneca, isn't it? The rules relating to patents clearly have separate objectives. We don't have that sharp distinction here. In fact, you could say the objectives are similar.
It includes, Ofwat's objectives include exactly what your Ladyship says. They also do include looking at wider issues for the purpose of the long-term health of the sector, including ensuring that there's sufficient investment over the long term and other matters. Because of that, and I can take you perhaps after lunch if necessary to relevant statements, it is true that one of the objectives is shared in that way, but the price control, the sectoral regulation, pursues a number of wider objectives as well. My Lords and Lady, if we now please turn up directly the claim form. You have that in the supplemental bundle at tab 3.
We don't get anything out of the CJEU.
No, I'm not going to refer to it separately, largely in the interest of time, but also because on the points that I've articulated, these points were I've not mentioned or they were upheld, they were approved, so it doesn't add anything. We go to the supplemental bundle to find the claim form. That's tab 3, beginning at page 124, and if we go in it, page 147, this is just to show you its shape. At the head of the page, you have section A, entitled Factual and Regulatory Background. And section A runs from paragraph 88 through to paragraph 151 on page 170. And if you go forwards to that page, 170, let's give you the paragraph reference, paragraph 152, you'll see a short section B entitled Market Definition and Dominance. And then under it, at the bottom of the page, you have section C entitled Abuse. Section C is where the case on abuse is set out. That's what I will focus on. After it, if you go, I'll come back to it, if you go to page 183, you have section D, for completeness, causation and loss. First paragraph in that section is 178. That's where causation and loss is addressed. So if I go back to the abuse section and look at paragraph 158 first on page 172. So here, this is picking up the thread from the last of the paragraphs that we were looking at in AstraZeneca. The basic proposition is that competition law applies in fields such as this, which are subject to specific regulation. And on page 173, in that paragraph, you have a list of points which are essentially quotations of propositions from other authorities. If you look particularly at subsection or subparagraph 2 and 3 near the top of the page, 2 says the courts have consistently held that competition rules apply where sector-specific regulation exists. 3, the competition rules may supplement, through an ex post review, legislative frameworks for an ex ante regulation of utilities market. So the 2 can be complementary in that sense. And this underlines the point in my submission that where competition law does apply in some regulated field like this one, it's not merely...
Nobody's saying that you couldn't theoretically have. It's just a question of whether section 18A knocks you out. I mean, it's a statutory construction question.
Yes, in that case, let me run briskly through these allegations so you see the case, and then we will turn to look at section 18A.
I thought the allegations we're looking at in the particulars of claim were directed at showing us that 18.8 doesn't apply to you because of the way you put your case.
Yes, the reason I'm doing this in particular is because you'll see from the tribunal's reasoning, it says the Supreme Court's position was that you should look for an essential ingredient of the claim, and one of the issues for this court is the meaning of the phrase essential ingredient. And they then go on to say, to work out what's an essential ingredient, you first have to look at the claim and what is pleaded. So that's why I'm just showing you precisely how the claim is put, and it may also help cast light on the debate we were having earlier.
I mean, it's very important not to substitute the words essential ingredient for the statute.
Oh yes, my lord, we entirely agree with that. And our concern is that to an extent the tribunal may have taken that phrase essential ingredient, applied it to the whole price control regime and said that's an essential ingredient in this case. And therefore, there's an ouster.
Let's have a look at this pleading anyway. We don't need to be persuaded you could theoretically have a claim.
Yes. So, paragraph 159, briefly at the top of page 174, makes the point that it's established that the competition laws apply fully to the water and sewage sectors. And you'll see from subparagraph 2, Ofwat's guidance, or part of it, which is set out there in italics, companies operating in the sector need to comply with both sectoral regulation and competition law. infringements of the Act may give rise to claims from third parties, which can be brought as either standalone or follow-on actions. Now, with that introduction, if you turn on to the specific allegations of misleading abuse in the case, those begin at paragraph 164, page 176 of the bundle. 164 and 165 afterwards, if you look at those are pleading that the claim concerns the provision of information to two authorities, the Environment Agency and Ofwat, concerning pollution incidents in circumstances where it ultimately affects the amount that can be charged to customers. Paragraph 167 pleads that the information on pollution incidents that the company provided to both of these authorities was misleading. It involved significant underreporting, such as to lead to higher revenue allowances and therefore higher prices. And paragraph 170 on the following page pleads that the various ways in which pollution incident information was objectively misleading and inaccurate will be the subject of evidence at trial, including expert evidence in the light of disclosure. And as to the sort of evidence that we have in mind that may be available at trial, an indication can be found in Ofwat's conclusions in its recently published report in respect of Thames Water. And you may have seen from Ofwat's submissions that they opened investigations back in November 2021 into all the companies' management of their sewerage plants and their networks. It wasn't focused on the licence condition dealing with reporting of information on pollution incidents. If you go in the supplemental bundle to the almost the end, tab 16, which is page 342, and look at page 348, this is part of our short submission responding to Ofwat's submissions on the regulatory regime. And I just draw your attention to paragraph 20, subparagraph 1, near the top of the page, to show you the sorts of factual consideration that would be relevant here. Under the heading spills from storm overflows at Thames Water's wastewater treatment works and on its network, they said, in our view, it's reasonable to presume that given the fact that so many of its storm overflows weren't being monitored or managed by Thames, that the true scale of spills across its network is likely to have been higher than the figures it had previously reported to the agency. The point there is that as a matter of fact, given the absence of the monitoring that took place, it could be inferred that the level of spills that were reported to the agency and fed through to Ofwat was lower than it should have been. And finally, if we now go back to the claim form, tab 3, look at page 184, starting at paragraph 181, you have the case on causation and loss. Begins at paragraph 181, and what that and the following paragraphs do is raise the issue of what companies' revenue allowances, and therefore the prices they could charge, would have been if different information about sewage spills had been supplied. And if you look in particular at subparagraphs 3 to 5 on page 185, 3, absent the abusive conduct, this is the misreporting, Ofwat's assessment of the defendant's performance against certain measures would have been based on the higher number of pollution incidents. That would have led Ofwat to impose penalties rather than rewards, or lower rewards, and therefore low revenue allowances. 4, if Ofwat had imposed such lower revenue allowances, the maximum prices for sewerage services that the defendant would have been permitted to charge would have been lower. And 5, as a result, had the defendant not abused its dominant position by providing the misleading information, the prices paid by the proposed class members, the sewerage services from the defendant across the claim period would have been lower than the prices they actually paid. Now, standing back, my submission is that you'll see from this that nothing here requires the tribunal to find behaviour by the sewerage company that constitutes formally a contravention of the regulatory duty. The tribunal is required to assess whether there has been underreporting that independently amounts to an abuse of dominance. And on the basis that it is an abuse of dominance to behave in this way, then for the purpose of assessing loss and damage causation, you're positing a counterfactual in which the abusive behaviour is absent, and you're not focusing at the loss and damage stage on whether the relevant acts constitute a legal contravention of conditions of appointment. So it is certainly the case, to return to what we were saying earlier, that this is inquiring into the impact on the price control regime. That's absolutely correct. One set of information has been provided rather than another set as a factual matter, but it is not opening up at the causation stage a new issue of contravention of the licence conditions. If I now move to the second topic, I'm going to come to the key provisions of the statutory regulation under the Water Industry Act. So in the first authorities bundle, you will find section 18 on page 11.
I just throw this in, maybe think about it at some convenient point, but as a thought experiment, what if the water companies in this case had just done nothing? They'd made no statements, they'd failed to comply with their obligation to report altogether, with the same effect, that Ofwat didn't have any information to go on, therefore assumed there were none. There were no PIs. Would the position be entirely the same on your case, or would that be a material difference?
To make sure that I understand the question, if against the background of the regulatory obligation, they simply nil return, no spills.
They didn't do anything, they didn't provide any return, because if they were provided a return, you could say that's misleading. So they don't do anything that can positively mislead, they simply don't comply with the obligation to report. Now, it may be slightly unreal, because I haven't followed up on it, but just to try and understand
it's a good way of testing it. The answer would be to consider whether the behaviour, more generally, of the company towards the regulator was such as to cause the regulator to impose a price control that has these bad effects from competition law, for competition law purposes. If it does do that, then it could sound as a competition.
No, I understand it. Yes, sorry. I assume it could sound in a competition claim. I'm asking this from the perspective of section 18.8. I should have made that clear. Does it make any difference to that analysis that they've done nothing? So there's no act or omission. Well, there's an omission. Well, the omission is merely an omission failing to comply with a regulatory obligation.
Yes, I don't think it affects the analysis. And we'll look at the moment at the relevant condition of appointments, essentially paragraph 9.2 of condition B, which imposes an obligation to provide information to feed into the price periodic reviews, the price controls. If the company doesn't provide any information, that will amount in a different way to a breach of paragraph 9.2 from the way that it applies if it does provide information but underreports. So to that extent, in each case, it is engaging the regulatory provision and there will be a contravention to that extent. From the competition law point of view, in the circumstances of the regulatory regime where all of this happens, the relevant question will be whether the way in which the company has behaved towards its regulator has resulted in it being able to abuse the system and therefore charge the higher prices in either case. My Lord, if we go to section 18 and just look at its provisions, it's under the heading enforcement orders, that part of the Act's entitled enforcement orders. Section 18 is titled Orders for Securing Compliance with Certain Provisions. That's all of section 18. That immediately flags up its specific purpose. And section 18.1, as you see, applies where Ofwat is satisfied, A, that the company holding an appointment is contravening a condition, and that's the present tense, or B, that the company is likely to contravene any such condition, anticipated. And so we see that the section is concerned with an enforcement in a scenario where there is either a current or anticipated contravention. That is why it is about securing compliance, or one could say securing future compliance. It has an active, forward-looking purpose and ambit. If, on the other hand, one is dealing with events in the past that no longer affect the price control, although there may have been misreporting, if it's backward-looking and spent, then section 18 does not apply. And part of our case, which you may have seen from the papers, is that we would say at least a great deal of our case is, in that sense, purely backward-looking. And so section 18 and the issue of contravention, which is forward-looking, does not bite for that reason. So in summary, even leaving aside that section 18.1 is exclusively concerned with contraventions of licence conditions, the first point to note is that it's not designed to address consequences of past wrongful behaviour by the companies, which is spent. And this understanding of the temporally limited scope of the key provision reflects what was reported to be Ofwat's public position in the Independent Water Commission's very recent report in July last year. You have that, if you would pick up the supplemental bundle, go in it to tab 12. Now, this has, of course, been in the news a great deal, but the stated objective of this commission, it's not in the bundle, I apologise, is to provide recommendations for a fundamental reset of the water sector to restore public confidence in the sector and its regulation. And if you go to page 318, second page of this tab, and look at paragraph 280 at the bottom, you'll see there that the Commission records under issues, the Commission has heard, this is after the bold text, that Ofwat's powers to impose enforcement orders are currently limited to those actions needed to secure future compliance. Ofwat suggested it could be beneficial to expand the scope of these powers to allow them to provide redress or remediation for the impact of company failures, in order to allow faster resolution of some cases and give greater benefits to customers. So Ofwat was describing the constraints on its power under section 18, it appears, to impose enforcement orders. And if you would now please go to the key part of the legislation for the purpose of this appeal, section 18.8. That is on page 13. and we need to look at its language closely. It says, and I'll jump over the superfluous words, where an act, any act or omission, A, constitutes a contravention of a condition of appointment, the rest, or B, causes or contributes to a contravention, the only remedies for or for causing or contributing to the contravention, apart from those available by virtue of this section, shall be those for which express provision is made by or under any enactment. And then the important words, particularly important, and those that are available in respect of the act or omission otherwise than by virtue of its constituting or causing or contributing to such a contravention. So on its face, it preserves rights of actions in respect of acts or omissions, such as we say here, the misleading submissions made to the public authorities, where the claim does not depend on showing that the acts or omissions constitute a legal contravention of the conditions of appointment. Then in the authority, we'll look at Manchester Ship Canal in a moment, because they looked at this very carefully to try to stress test its limits. If you go over to page 18 in this bundle, you have the following section of the Act, section 19, exceptions to the duty to enforce. And there you have a short list of exceptions, such as triviality. And if you look at the foot of the page at subsection 1A and over subsection 1B, focus perhaps on section 1B, it provides that Ofwat shall not make an enforcement order under section 18 if it considers it would be more appropriate to proceed under the Competition Act. And just for your note, the statutory provision entitling Ofwat to apply the Competition Act is section 31. Section 19 here is showing that the legislature has in mind that competition law duties can, in principle, relate to the same acts or omissions as also constitute legal contraventions of conditions of enforcement of appointment, which are subject to being enforced under section 18. And that is why the authority has a choice, and it can decide between whether it will use one toolkit or another. That prompts the thought experiment which we posed in our supplementary skeleton at paragraph 29. If you suppose that in the present case, Ofwat had itself proceeded against the respondent companies for the abuse of dominance that we allege, and this is on the predicate that it is a well-arguable competition case, and Ofwat has decided, looking at section 19(1)(b), that it's going to apply its powers under the Competition Act because of these misleading statements that were made to it, albeit in the context of the regulatory obligation. If that's happened, and Ofwat reaches a final competition law infringement decision against the company, and then after that, Professor Roberts brings a follow-on damages claim against the companies on behalf of the millions of overcharged householders, we say it would surely be plain that her follow-on damages claim is not relying on the contravention of conditions of appointment to make it good, whether at the breach of duty stage or at the causation stage. The circumstances would be that Ofwat itself has intentionally chosen not to proceed by way of enforcement proceedings, which require demonstrating contravention of the conditions of appointment, but to apply competition law directly. And if I may, the final section of the Act that I'll take you to is section 22A, which you see on page 27 of the bundle. This concerns penalties. And subsection 1A says that where the authority is satisfied in the case of any company holding an appointment that the company has contravened or is contravening a condition of appointment, and so on, it may proceed to impose penalties. So here, in contradistinction to section 18, which had expressed itself in the present and future tense, the penalties provision also has a backward-looking stance. You'll see from subparagraph 9 on page 29 that any sums received by way of penalty go into the consolidated fund. They're not directed to redress for overcharged customers. And finally, may I invite the court to turn up the conditions of appointment, which are relevant, or potentially so, to the reporting of pollution incidents. Condition B, paragraphs 9.1 and 9.2. And the easiest place to see these is in the tribunal judgment itself, in the core bundle, tab 10, bundle page 97. So it's in paragraph 9 of the tribunal's judgment, if you're looking at it on screen. Towards the bottom of the page, the tribunal sets out paragraphs 9.1 and 9.2 of condition B of the conditions of appointment. 9.2 is easy to grasp. There's a duty to furnish to Ofwat such information as Ofwat may reasonably require to enable it to carry out a periodic review. And that may include information on pollution incidents. And so either not complying at all or providing the wrong number may be said to be in breach of that. But to the extent that sewerage undertakers do provide misleading information, therefore, that may amount to a contravention, and at the same time, that act in that context sounds as the breach of the competition law duty. Condition B, paragraph 1, above it, bless you, is not about providing information to Ofwat, it's not what it says. It's a duty to levy charges in a way best calculated to comply with the price control which has been determined. And at the hearing below, you will have seen, and subsequently, Ofwat has put forward a candidly untested position that it could impose an enforcement order if a company is levying charges based on misreported information about pollution incidents, to direct the sewerage undertaker to restore any overcharge to the customers. So this was a novel point that arose essentially at the hearing below. And what you will see presently is that in its judgment, the tribunal takes comfort from that as meaning that despite its finding that these well-arguable claims are excluded, residential customers who are overcharged do have the prospect of compensation or reimbursement through this
Which
mechanism.
paragraph in the judgment?
Paragraph 51.
51.
51.
Thank you.
Now, we saw that one potential point in this case is that the enforcement power concerned within this case does have only a present or forward-looking quality to it. So that if this claim is concerned with things that occurred in the past, you're not therefore able to now use the powers under Section 18 as a mechanism, an ingenious mechanism to provide redress. So we pursued this with Ofwat in the written submissions ahead of this hearing and in an exchange of correspondence. And we pointed out that the enforcement order power in Section 18 is limited in this way. It looks at current or ongoing or anticipated contraventions, not past events. And we said, so for example, if Professor Roberts shows, part of the claim, that there has been abusive reporting of pollution incidents by Severn Trent back in 2017, and that affects the amounts that Severn Trent could charge under the price control regime 2 years later in 2019, it was hard for us to see how that could be said now to be relevant to Severn Trent's current or anticipated charging behaviour. So we asked Ofwat to clarify its position. And if you go in the supplementary bundle to page 351 in tab 17, you first have our request for clarification there. It's quite a short letter, dated 9th December, page 351. We ask Ofwat to confirm our understanding, and in paragraph 3 in particular, we asked if Ofwat's position was that it could use the enforcement powers in section 18 in effect to provide financial redress for customers based on underreporting throughout the claim period. And we sought to crystallise the point in the last 3 lines there that in many instances any such underreporting will have affected the relevant revenue allowance in the year that has now ended. So we asked Ofwat what it said, and their response is in the next tab, 18, 22nd December letter, page 352. In paragraph 3 in that letter, if you look at the last 4 lines, Ofwat states its position that the enforcement power under section 18 encompasses the making of orders which are both to prevent likely future contraventions and to bring ongoing contraventions to an end. So we're ad idem as to that. And then if you look at paragraph 4, just below, at the bottom of the page, in italics, just above A, you have our request for clarification, whether Ofwat contends it can use its power to obtain redress for customers for matters affecting, say, charges back in 2018. And Ofwat's response in that subparagraph A is, responsibly, that the use of enforcement orders for this purpose is untested in practice, and they don't consider it appropriate to comment in circumstances where it's hypothetical. And they end by saying Ofwat has made no submissions and takes no position in these proceedings on the specific question of the application of its enforcement powers in the present case. Having said that, in letter B immediately below, they point out in Roman 1 and Roman 2 that the reporting obligations in 1 year of the price control, or in one price control period, can have a knock-on effect on the working of the price control in another year or a later period. And at Roman 3 they say because of these connections, that the way it works and with this knock-on effect, depending on the circumstances, misreporting in one past year may continue to be relevant to current or future charging. So that illuminates how they see it. And for completeness, if you just go to the final page of their letter, bundle page 355, you'll see that in paragraph 6, Ofwat essentially repeats what it said in the earlier paragraph, and halfway down it says it won't comment on the hypothetical question whether it considers it could make an enforcement order dealing with current or anticipated charges to address misreporting which has occurred in the past. That's therefore the...
which paragraph is that?
Paragraph 6 on page 355.
I'm sorry, while you're there, would you mind reading to the end of that paragraph?
Yes.
Thank you.
Paragraph. That's fine. Ofwat's position is that its powers under section 18 would permit it in principle to make an enforcement order requiring repayment to customers of charges that had been unlawfully levied in breach of licence condition B, in an appropriate case, I emphasise. Ofwat hasn't addressed and doesn't consider it necessary to address the question whether such an enforcement order could be made in respect of the specific matters alleged in this case.
But this is all years ago, and they haven't done. So
Much of it is years ago, and they didn't do. Yes. So with that,
So your position, in any event, as I understand it, is that enforcement orders are for present or likely future conduct, but the penalty regime encompasses past conduct.
Yes.
Clearly,
Yes.
as I understand the statute.
it does, and the
And just for completeness on that, some regulators have used their own penalty regimes to say, we'll impose a penalty unless you refund customers.
yes.
There's no hint of that. I've seen no hint of that in these proceedings.
In relation to these claims, that is right. We have made the point, and find it for you in pleadings if necessary, but we make it in our submission as well, our skeleton, that if it is the case that by such a means the class members sought to be represented did get effective redress, that would be credited in any claim for damages based on competition law. But it hasn't, you're correct, it hasn't occurred in these cases.
But Ofwat has referred, hasn't it, in some, it was a response to evidence or something, Ofwat referred to the fact that that could take place. Companies could offer that.
Yes, it has.
Yes.
Yes, and it's absolutely fair as a completion of the picture. So I turn with that to topic 3, keeping an eye on the clock. This is the Supreme Court's consideration of that subsection, section 18.8, in Manchester Ship Canal 2. You find this in the Third Authorities Bundle, tab 14. This case obviously forms an important part of the tribunal's reasoning in reaching its decision as to exclusion, so it is necessary to look carefully at what it says. My respectful submission is that in the way that I foreshadowed, the tribunal appears to have mistaken what it means. And I'll take you to the most salient paragraphs now, what we consider to be most salient, and seek to show you that the case stands as authority for 4 relevant propositions. Number 1, the basic point, which I trust isn't in dispute, it's a basic principle that legislation is not to be construed as depriving individuals of rights, and that will include here an arguable claim under competition law and vindication of those rights, unless it does so expressly or by necessary implication. 2, section 18.8 bars a claim for a remedy in respect of a legal wrong only where establishing contravention of a condition of appointment is an essential ingredient of the cause of action, phrase consistently used by the court.
by the contravention. Say that again.
Yes, it bars a claim for a remedy in respect of a legal wrong only where establishing a contravention of a condition of appointment, so here breach, let us say, of condition 9.2, is an essential ingredient of the cause of action. Here's the competition law cause of action, in the sense that, I underline that, the underlying act or omission relied on doesn't otherwise give rise to an actionable breach of statutory duty. 3.
Wait a minute.
Yes.
Yeah.
Point 3, corollary. If certain acts or omissions do constitute contravention of a condition of appointment. They do. And if they are at the same time a breach of an independent duty, another cause of action, the claim for a remedy is not barred. And 4, it's related, the fact that the underlying cause of the loss or damage which has been suffered are acts that do amount to contravention of a condition of appointment also is not something that entails the claim for a separate remedy is barred or excluded. Or put another way, it doesn't make a difference if complying with the condition of appointment would have avoided the occurrence of the loss and damage. It doesn't make a difference if the duty to provide the information arises under the statute. And if I can turn directly to the case, I'll take you to certain key paragraphs alone. Mr. Hoskins joked that we were going to need to go through 200 years of sewage regulation, but I'm going to seek to avoid that.
I was hoping you'd see it.
Yeah. Well, I'll leave that to you. So I turn directly to this. The facts were that the owners of the ship canal were threatening to sue United Utilities. That was the relevant sewerage undertaker. The damages in trespass and nuisance because of discharges of raw sewage in contravention of the statute. The sewerage undertaker sought a declaration that it's a contravention, such a claim is excluded because of section 18.8. And the only remedies available to you are those which are provided by the enforcement provisions of the Water Industry Act. The judgment is given by Lords Reid and Hodge, with whom the other members of the panel agree. And I'll take you through the key paragraphs to illustrate the propositions I've outlined in a logical sequence, although this will not always follow the order in which they appear in the judgment. We begin at paragraph 20, which is on page 583, letter A. You see the first sentence. The test of inevitability reflects the wider principle that legislation isn't construed as depriving individuals of their rights unless it does so expressly or by necessary implication. That's the general principle. Then if you go forward to page 596 and look at paragraph 53, you see the discussion of the Water Industry Act 1991. And the point is made here, 4 lines down, that the Water Industry Act 1991 is a consolidation statute, and that this is of some significance, their lordships say. Such statutes are not intended to make substantive changes to the law, but to present the existing law in a newly organised structure and in language that's modern and internally consistent. And over the page, 597, they set out section 18.8 within paragraph 56 at letters C to E. And what they do is to italicise the key saving words at the end of the provision. And then you go to paragraph 57, which is one of the paragraphs relied on by the tribunal below. Their lordships state that these words expressly preserve any common law remedies that are available in respect of acts or omissions which contravene a statutory requirement enforceable under that section, where the contravention of the 1991 Act is not an essential ingredient of the claim. In other words, if a sewerage undertaker's act or omission gives rise to a cause of action at common law, the fact that it also contravenes or contributes to the contravention of the Act doesn't prevent the courts from enforcing the affected claimant's common law rights and awarding any available common law remedies. That's how they explain it, and they say it reflects the pre-privatisation law. The pre-privatisation law was comprehensively examined in the early paragraphs of this judgment, and it was then very conveniently summarised in the list of propositions which you find in paragraph 50 of the judgment, which begins on page 593.
Where do the words that Lord Reed used come from?
I'm sorry, where did the words?
He says, you know, he expresses the principle by saying, using the words essential ingredient. Where do those words come from?
Those words do not predate, I believe, this judgment. And for that reason, and when you see them used by the Supreme Court, my submission is that they're not meant to be additive. They are by way of a conclusionary statement of what is meant by section 18.8 and nothing more than that. What you see in paragraph 57 and in certain other paragraphs is that the court is saying, well, look, this is what the language says. In other words, and then they use the term essential ingredient essentially as in the form of put another way.
Well, they don't say in other words. That's in the fifth line of 57.
No, not here. No. Your lordship's. I'm sorry.
Is it perhaps fairer to treat the words essential ingredient as the Supreme Court's way of rationalising the earlier case law?
Yes.
Including Marset. I mean, I've probably got the Marset case in particular. I don't know if I've pronounced that correctly.
Glossop. Yes. It was there. It was not a phrase that, to my knowledge, you find in the earlier cases, and they looked at all of them. It was their way of summarising what they understood section 18.8 to involve. And for that reason, when one is unpacking the phrase, one needs to attend or can't lose sight of the statutory provision itself. We must drink from the pure waters of the statute. Sorry, I said that for that reason. If we go then to paragraph 50, begins on page 593, and this is the list of the propositions that they draw from the earlier authorities. And I'm just going to invite you to read two of the propositions in sub-paragraphs 12 and 13, which you find at the top of page 595. 12, the existence of a statutory remedy won't bar an action where the relevant act or omission is not only a contravention of a statutory duty, but also constitutes a tort. And my lady's right, that's the point. They refer to Glossop, as well as two other cases. 13, an action may lie against the sewerage authority in respect of a nuisance for which the authority is responsible, where the cause of action does not include, as an essential ingredient, that the authority has failed to drain its district effectually, which was an obligation arising only under that piece of legislation. That is so, notwithstanding that the nuisance has been caused by such a failure. They refer to various authorities, including Pride of Derby. So in the present case, even if complying with the conditions of appointment requiring accurate and full reporting would have avoided the loss and damage, the misleading of the regulator, the underreporting so as to be able to raise charges, is nonetheless, it's independent and it is therefore actionable, and the saving words apply. There are a couple of other paragraphs to look at. If I can ask you to go to paragraph 89. This is at the foot of page 605, letter H. And now we're in the part of the judgment where what the Supreme Court is doing is explaining an earlier House of Lords decision called Marchek and Thames Water. And this is at the foot of page 605, letter H. And their lordships clarify that a common law claim in nuisance isn't excluded in every case where preventing the nuisance would involve capital expenditure. And they say that it's noteworthy, 4 lines from the bottom, that both Lord Nichols and Lord Hoffman indicate that the 1991 Act didn't exclude liability for nuisances resulting from the inadequate cleaning or maintenance of a sewer, those duties. That is significant, they say, because cleaning and maintenance, those are statutory duties imposed by the water legislation, which are capable of being enforced by the statutory procedure under Section 18. And that's relevant to our case because it shows that even where the mischief complained of is subject to enforcement using Section 18, it doesn't bar a private claim, and that the touchstone, whether the exclusion applies, is whether an essential ingredient of the cause of action, properly understood, is a duty that you don't find anywhere other than in the Water Industry Act. Whereas here we say that there is a duty you do find other than in the Water Industry Act. And my second and final reference is paragraph 133 on page 618. This is the key conclusion, within the key conclusion relevant to this case. I think this is one of the ones referred to by the tribunal as well, but I may be wrong about that. If you look at letter D, the court says, the only ouster by section 18.8 is of causes of action of which a contravention of a condition of an undertaker's appointment or licence or a statute or other requirement enforceable under that section forms an essential ingredient. It's not sufficient in a case of this kind, we say, to observe, as the tribunal does, I'm coming to it now, in the critical part of its judgment, simply that the failure to supply accurate information for the statutory price control regime is an essential part or ingredient of the case. That, we say, is ultimately the error that was made, because if that failure to supply accurate information within the framework, within the context of the regulation, sounds independently in competition law as a breach of a competition law duty, which the tribunal agreed it does, Manchester Ship Canal confirms that section 18.8 does not exclude the claim. So those are my propositions and understanding of this judgment. What I'll do in my remaining time is turn now to the tribunal's judgment and to the relevant part. The tribunal's judgment is...
Sorry, just before we move on, can I just test one point? On the facts of Manchester Ship Canal, the nuisance, the fact that what was done was also a breach of the regulatory regime was really happenstance. All the ingredients of the common law cause of action were there. And the regulatory regime, in a sense, had no impact on that. And in fact, the Supreme Court placed a lot of emphasis on that's your private law right, not to have that nuisance committed against you, and that's not been taken away by the regime.
Yes.
Here, what's happened is only in the context of the regime, and this goes back to the point I made earlier about the information's only provided, there's only that dialogue with the regulator because of the existence of the regime.
Yes.
So you've got a harder, this is a more tricky case from that point of view.
That is a fair distinction, and I'll dwell on it for a moment. In, as you say, in Manchester Ship Canal, the discharge of the sewage into the canal independently creates a form of damage which, leaving aside the statutory regime, it's a point made by the tribunal in its judgment, as we'll see, it's damage regardless. What the Supreme Court does, however, in Manchester Ship Canal, in the part we were just looking at, the distinguishing of the Marchett case, is that it says that in Marchett, the earlier case, the common law action was excluded for a very particular reason, which was that there, the breach of duty that was relied on, based on a case called Sedley Denfield, was ultimately the failure to build more sewers. And the court said that that duty, the failure to build more sewers, you don't find anywhere other than in the Water Industry Act legislation. And that is why Marchett was excluded and this case not. Your ladyship makes a very pertinent point that this case, in a sense, sits between those two poles. Because here we do have an independent duty because competition law recognises that even in a field which is subject to this form of regulation, that the act of misleading the regulator, let us say in breach of that regulatory obligation, is also recognised as having a competition law consequence for the purpose of an independent cause of action. That was not the case in Marchett. Your ladyship is right that it's a fine point of distinction to make with Manchester Ship Canal's facts, but it does not affect the fact that in this case, in our case, there is an independently actionable breach of duty arising that competition law will recognise.
So it is an essential ingredient, but you say that doesn't matter because there's also a freestanding cause of action. So Manchester Ship Canal does not decide this question.
Well, that is because I'm interpreting essential ingredient, as we say the Supreme Court was doing here, to mean you won't find the cause of action anywhere else but in the statute. And if that is the case, which is what Section 18.8 is directed to excluding, it will be triggered. But where the very same facts are a contravention, my ladyship is absolutely right to say that they are a contravention, and even if you had not contravened, you wouldn't have had a problem. Nonetheless, if you have an independent cause of action which says that misleading a regulator in this sort of context can found a breach of the duty, then you don't have the exclusion.
Yes.
So subject to that precision about what the term essential ingredient means, I think we're ad idem on that point.
Could it be said, the distinction of markage in the MSC case, I think you said the reason it was distinguished was because the failure to build more sewers, it was the action was based on the failure to build more sewers.
Yes.
And you don't find any obligation to build more sewers otherwise than the legislation.
Yes, that's what it says.
So in this case, it might be said, that the case here depends upon a failure to report to the regulator, but the only place you find an obligation to report is in the legislation.
That is where the only place where you find it, but at the same time, competition law says that in that situation where there is such a manipulation, or at least this is the arguable case, that will be sufficient to ground a competition law duty. So I accept that the matter arises in the context of the contravention, but in answer to your Ladyship, and I'm grateful to you for raising this precise point, that is the distinction that is made, that you have a cause of action which precisely is about misleading a regulator.
I think you need to say that despite the fact that the motivator, if you like, for providing information to the authority is the regulatory regime, if you in fact provide it and it is misleading, that is enough to trigger the that is the basis of the competition law cause of action. And you are not needing, I think you need to say effectively that you're not needing to, in order to demonstrate your competition law cause of action, you do not need that earlier context of the regulatory obligation to provide the information.
Correct.
I think you need to carve it up.
Well, no, that is right. That is the gist of it. From competition law, from the competition law point of view, stand back. You observe a situation where a dominant undertaking has misreported to a regulator, and it has had these adverse competition consequences. Those are the critical facts. Those facts have arisen in the framework of the sectoral regulation, but your Ladyship puts the point extremely well. That is how competition law looks at it. So for this case, and for making it out if this proceeds, we shall be looking at whether there was in fact this misreporting, underreporting, having those adverse consequences. And your Ladyship is quite right to say that that is therefore abstracted from. It is not yoked to proving a legal contravention. So we turn then to the tribunal's judgment itself. And this is the subject to looking briefly at the respondent's notice. This is the last but most important part of the submissions. Tab 10 of the core bundle. The relevant part begins at page 102. The heading is D, are the claims excluded by section 18 of the Water Industry Act?
Which paragraph?
Paragraph 25, my apologies. Tribunal begins, we need to just walk through this. The tribunal begins by setting out the text of section 18.8, which we've looked at, and like the Supreme Court, it italicises the key saving at the end. It then breaks down the requirements of section 18.8 into three separate questions articulated originally by Mr. Hoskins. First question is whether the acts or omissions complained of constitute contraventions of a condition of appointment. That is the predicate, subparagraph A of section 18.8 applying at all. Second question is whether remedies are expressly provided for such a contravention under any enactment apart from section 18. It's common ground they aren't. Third question refers to the italicised text at the end of this quotation, section 18.8. Are the remedies sought in these proceedings available in respect of these act or omissions otherwise than by virtue of their constituting or causing or contributing to the contravention. The tribunal considers question 3 as the critical one. And we say it is subject to the nuance that I mentioned at the outset concerning whether in practice Ofwat was at the time under enforcing the provision, in which case the fact that Ofwat itself fails to find the contravention is not decisive, because objectively, if they should have accurately and fully reported, that is the relevant matter. The second point is, of course, that this only concerns the reporting to Ofwat. And as we've floated earlier in this hearing, there is also the information submitted to the Environment Agency, which is the first port of call, where Section 18A doesn't apply at all. So if we stay in the judgment, paragraph 30, the tribunal sets out an extract from paragraph 57 in the Supreme Court judgment that we've looked at, referring to essential ingredient. Paragraph 31, the tribunal sets out the Supreme Court's effective conclusion in paragraph 133 of its judgment. We've also looked at that. And that stated that the only ouster is of causes of action of which a contravention of a condition of appointment is an essential ingredient. And what I've sought to show you from the Supreme Court's discussion, the paragraphs that I went to, and in our debate, is that it means we say straightforwardly that when you are bringing the competition law case, you ask yourself whether you need to appeal to the contravention of the conditions appointment in order to make good your claim. If you do not, then contravention is not an essential ingredient of the competition law claim. Paragraph 32, the tribunal says that the question whether contravention is an essential ingredient of the pleaded claims has to be addressed by looking at the claims. We agree with that, insofar as it's based on correct understanding of the term essential ingredient. And we say it's from this point in the judgment that cracks in the reasoning do come in. Rather than going to the part of the claim form which you've seen is concerned with setting out the elements of the case dealing with abuse, in paragraphs 33 and 34, the tribunal quotes from the factual background section, which does indeed record that under the respondent's licence conditions, they're required accurately to report the number of pollution incidents. The section in the claim form begins after that, as we saw. Paragraph 35 of the judgment refers to the claim form at paragraph 164. So that's the first of the paragraphs in the relevant part of the claim form. And I was going to invite the court just to pull up the claim form again, which is at supplemental bundle 3, and just quickly look, if you would, at page 176. This is partly to follow the ladyship's point, because you see there what is articulated as the matters that must be established in order for the claim to succeed. And you will see in those paragraphs, to follow my ladyship's point, paragraphs 164 to 166 set out the, as it were, factual point that the information reported to both the Environment Agency and to Ofwat fed into the charges that the respondents could impose on the household customers and led to the adverse competition law consequences. It is not necessary to show that this amounted to a regulatory contravention. Now, if you would return to the judgment, we'll come to the thorny paragraphs. First, continue paragraph 36. The tribunal rightly cites a key paragraph of the abuse claim, which is 167, explaining why the pollution information is relevantly misleading.
So which paragraph?
36
Yeah.
of the judgment. What one sees here again is that the facts that are pleaded, which require to be established, do not depend on showing contravention. Paragraph 37 also correctly sets out a key paragraph of the case, now on causation, in paragraph 182, and it makes the simple point that in the absence of the abusive conduct, this is if you look at subparagraph 5 at the top of page 106, in the absence of that conduct, the prices paid by the proposed class members would have been lower. Paragraph 38 is concisely recording the argument of the sewerage undertakers, and that is resurrected on this appeal and through the respondent's notice. The tribunal summarises it very crisply. The defendants contended the claims were founded on the obligation to report pollution incidents to the regulator. They submitted if there was no condition requiring the defendants to make these reports, there could be no allegation of non-compliance. As Mr. Hoskins put it, the touchstone for determining whether the regulator was misled is the appointment condition and the obligation to comply with it. If there was no breach by the defendant of its reporting obligations, the claims would fail. So we have essentially a group of propositions there. First, that the claims are founded on the obligation to report, the regulatory obligation, and if you don't have that condition, there can't be an allegation of non-compliance with it. Non-compliance with it. That's the allegation. Secondly, the touchstone for determining whether the regulator was misled is the appointment condition and the obligation. And third, if there was no breach of that reporting obligation, the claims wouldn't run. And we say the essential error in these contentions, broadly, is that they are eliding the circumstances giving rise to, or the context of the factually misleading behaviour, the legal and factual context, namely that the companies are required to give accurate information on spills, with the factually misleading behaviour itself. For the case, we observe that they provide a lower number of spills by way of input into Ofwat's processes than they could and should have done with the adverse consequences. The relevant question for the abuse claim, therefore, we say, is whether the sewerage undertakers provided misleading information in that way to these two authorities, leading them to be able to reap unjustified
You accept that the misleading information, the provision of misleading information was in fact also a breach of the condition. 9.2, 9b.
Yes, I think for present purposes, yes, subject to the two qualifications I've entered, one of which is important. The first was the nuance that there may have been practical under enforcement in the way that I've described. The second is that a part of this case, and an important part, is that the way this works is that they provide information on the spills, the incidents, to another agency, the Environment Agency, Ofwat, and they do so under a separate regime which doesn't have a section 18.8. And they are therefore, if you look at the competition law claim, they are misleading the authority in that sense. And there's no section 18.8 there.
Which authority?
The Environment Agency. But by providing it to the Environment Agency, the information of the Environment Agency, by underreporting the spills for their separate purposes, which are environmental.
Why is that relevant to the competition claim? There's no consequence of that, is there, in competition terms?
There is.
There is?
Well, yes, there is, because it is as a result of that it feeds through into in practice, into Ofwat using that information in its price control.
So the only relevance is it's a pass-through, effectively. The information is passed through the Environment Agency to Ofwat.
That is the relevance. I wouldn't say it's the only relevance because it's a key part of the factual matrix that they do provide. They underreport the information to the Environment Agency. The Environment Agency, and this is simply the arrangements between the two authorities, the Environment Agency provides that information to Ofwat. In tandem with that, the companies do provide information directly to Ofwat. But the price regulator depends on the Environment Agency's information, and it says, and it has said in its submissions, that they regard a contravention to have occurred, or they will do so, only if the Environment Agency considers that there has been underreporting. So they say in their skeleton argument, I think it's paragraph 15.2, perhaps we should just go to that now. If we make a quick detour into the supplemental bundle and look at Ofwat's skeleton, which is at tab 9, and in it go to page 272, paragraph 15.2. If you have that either on screen or in hard copy, what they say is, if after Ofwat's reached the price control decision, further or better information becomes available about pollution incidents, e.g. as a result of devices called event duration monitors, the relevant question for the purpose of these price controls will be whether the Environment Agency recognises the further pollution incident. And the point here is simply to observe that in practice, if they provide false or misleading information to the Environment Agency, the way that this works is, in practice, it creates the advantage, their ability to charge the higher prices, which is the subject of the competition claim. So, your Lordship's right, it is a form of essentially passing through, it is a chain, but it is a material part of the abusive behaviour that is alleged in the claim form. Yes, Mr. Gregory refers me to our pleading. Let's look at that. So, supplementary bundle at page 156 in tab 3. Paragraph 116. That the pollution incidents reported to the EA, the Environment Agency, whether self-reported by a company or reported from another source like a member of the public, this is how it works, they're logged by the agency on its system. Among other things, the agency records its determination as a particular category, whether it's in breach of the environmental permit, and then that essentially is what is used by Ofwat, and it takes that, and unless the agency is then prepared to say subsequently there has been misreporting, Ofwat will not itself independently find that there was. So there's a form of mismatch that is required. And that is why in paragraph 15.2 of its skeleton they say that this is the relevant question. So, returning to the judgment, the point I was just going to add, we were looking at paragraph 38, is that we know from Manchester Ship Canal it is not a good argument that if you don't have breach of the obligation to report pollution incidents accurately, there's no damage. One of the points that was made on the respondent side, because that is a causation argument, and the Supreme Court did make it very clear that the exclusion isn't engaged on the grounds that a contravention can be said to be the underlying cause of the damage suffered. The premise is that you observe underreporting, which has caused loss to the claimant. Those are the key facts for the competition claim. And irrespective of the legal status of that, clothing it as a contravention, it is that behaviour which operates as the but-for cause of losses, in respect of which you're claiming a remedy. And if you were to reason that the Act constitutes a contravention, meaning that a contravention is the underlying cause of the losses, and then say, well, that in itself is sufficient to exclude a claim which is brought on the basis of another cause of action, then the italicised final wording in section 18.8, in one sense, is otiose. The key question is whether the claimant is or isn't relying on matters that, under the competition rules, amount to a breach of duty. And here, as I've said, reliance on factual misreporting, distorting what the companies can charge to householders, is just that.
Did you say matters that amount to a breach of duty?
Yes, and by that I mean a breach of duty under the Competition Act. So the underreporting, which is apt to have these consequences, enabling the company to charge the higher prices. Those are the facts that give rise to the abuse, we say. At all events, the tribunal has recorded Mr. Hoskins' points there in paragraph 38. In paragraph 40 of the judgment, very shortly, the tribunal agrees with our conclusion, and it puts it very crisply, reading from the third line. We see some force in the PCR's response that for a dominant undertaking to mislead a public authority is in any event an abuse. They deal with it that shortly. So at this point, the tribunal's with us, and then the error, which is the subject matter of this appeal, comes into the reasoning in paragraphs 41 to 49. To return to what I said at the outset, we have no problem with paragraph 41, or indeed paragraph 42, in and of themselves. Those paragraphs are observing that to show causation, Professor Roberts intends to look at the difference between the prices that were actually charged by the sewerage companies and the prices which they would have charged if the information on pollution incidents they'd supplied had been full and accurate. It is paragraph 43 that is the first critical paragraph, and that requires this court's careful attention. The tribunal says in the first sentence that the price control mechanism imposed by Ofwat is therefore integral to the loss allegedly suffered. And what it has just been looking at is this pleading in relation to how loss and damage is going to be established, comparing one set of information with the other and the consequence. And it is because of that that they say, in our view, the price control mechanism is therefore integral to the loss allegedly suffered. Pausing there and following the debate with this court so far, it is. In the second sentence, the tribunal also says, quite correctly, that the damage allegedly suffered and the remedy sought arise only by virtue of the fact that the reporting of pollution incidents fed into the determination by Ofwat of the revenue allowance. Pausing there, that also is quite right. But then it adds these words, and the potential prospective defendants, the defendants, contravenes the conditions imposed on them to supply Ofwat with accurate information for that purpose. And that is where we say the misstep occurs. That phrase, or those words, do not belong here. There is no reliance on contravention of the conditions of appointment at the causation stage, any more than there was at the abuse stage, which the tribunal was happy with a few paragraphs back. What the claims require is a comparison to be made of what was actually charged with what would have been charged, and we have an economist who will look at that, and it does not require consideration of the legal issue, whether there was a contravention of the conditions of appointment. Causation case that will be run does not involve that legal question. The next sentence in paragraph 43 also, we say, reveals a gap in the logic, and even more clearly. Here it says, put another way, the failure to supply accurate information for the statutory regime of price control under the Water Industry Act is an essential ingredient of the PCM's claim for breach of statutory duty under the Competition Act. It's right that the failure to supply accurate information, as my ladyship pointed out, as a factual matter, is a necessary element of the competition law claim. It is another way of saying that the factual underreporting that facilitated higher prices is a necessary part of our case. But it is not the case, and the tribunal does not say it here, that proof of contravention of the conditions of appointment is an essential ingredient of the damages claim. And again, to crystallise it, Professor Roberts is relying for the competition case on the observation of factual underreporting that facilitates higher pricing in its own right.
So there's nothing wrong with that sentence then in itself, put another way.
No, that's right.
Yeah.
Yes, that sentence is correct, but it is not. It is now detached, unmoored from the reference to the contravention, which was the key point. If you go back to the language of section 18.8 and those italicised words.
I mean, speaking only for myself, it seems to me that you may well be right about 43 being wrong, because there was no contravention involved in a miscalculation by Ofwat of information given to it. The contravention wasn't a contravention at all. It was a performance of the regime it was entrusted to deliver.
Yes.
The contravention, if there was a contravention, was at the earlier stage when you provided the wrong information.
Yes.
And the question that, anyway, I find difficult to answer at the moment is that there seems to be an acceptance, subject to all your caveats about the Environment Agency, which I believe to be a bit of a digression. You accept that it is an essential part of your Competition Act claim that there was a failure properly to report, which amounted to a breach of the condition and the Ofwat regime. And the question is, if that is the fact, and you have a contravention of that, and you have an essential ingredient in a free-standing cause of action, which is the misreporting, could have been to the patent authority, but it wasn't, does that invoke the section? And I don't think the case Manchester Ship Canal tells us the answer to that.
Well, first, that's very helpful. I will nonetheless just complete the analysis of
Yes.
what the,
course.
tribunal dealt with in relation to the causation stage. But your lordship, if I may say so, is absolutely right, which is that if this is an issue, really...
Because as you say, it sits between the two cases.
Yes.
Church and,
Yes, and we should be... Yes, and if it is an issue, we should be looking at it in relation to the question of abuse.
and the tribunal didn't really address it because they just said, I mean, Mr. Hoskin says they were wrong in paragraph 40, 38, is it? 40?
Yeah.
I can't remember the numbers. Anyway, there we are. That seems to me quite an important point. But let's carry on with 30. Let's carry on with 40.
44.
Following.
Yeah, my lord, the only point I'd make is, and perhaps I will need just to return to this after the short adjournment, is that in Manchester Ship Canal, in the paragraphs that I took you to, you do have assistance on this issue, because there the Supreme Court was very fierce on the point that you can have an act which is complained of, which is meant to be enforced by the statutory regime in question here, which may be the cause of the loss that is claimed, but that doesn't matter. They construe the exclusion correctly, voice of infallibility, very narrowly, which is to say the exclusion applies only if contravention is an essential ingredient of the claim you have to prove in court. And our answer, in the simplest terms, was that articulated by my lady, which is that the competition claims depends on observing that there is underreporting, and explaining this, showing that that underreporting had these adverse competition consequences, and that those consequences resulted in these substantial losses. And that her ladyship was quite right to draw my attention to a difference between the facts in Manchester Ship Canal and our case in that way, and I've sought to give, at least indicatively, my response to that. So in paragraph 44, if I resume, the tribunal is now distinguishing a situation, as relevant to the discussion we've just had, in which the prices charged by the sewerage undertaker, in and of themselves, you would look at them, you would analyse them based on the competition law toolkit by itself, and say they are excessive and unfair on the basis of a particular line of jurisprudence beginning in United Brands. And you don't need to consider the abuse of misleading the regulator at all, the AstraZeneca way of putting it, or any other form of misconduct. You just focus on those prices and examine them according to the metrics familiar from that line of authority. The United Brands argument would be a different kind of case from this one. We say this is irrelevant. But what it does cast light on is this. It suggests that the tribunal's perception, we say misconception, is that if you do have a case where it is necessary for the claim to consider how outcomes under the price control would have been different if the respondents had given the different information, the tribunal says, well, in that sort of case, because essentially the operation of the regime is inextricably part of the claim, particularly comes in at causation, that entails reliance on proof of contravention of the conditions of appointment. And perhaps that also serves to explain why the tribunal was so focused on the causation stage rather than the early abuse stage. Because in the early abuse stage of our claim, as my ladyship points out, what we're doing is looking at the amount of reporting that took place and the amount that should have taken place. And we're showing that there was a mental or deliberate misreporting may be a part of it, there was culpability there. And that, in order to prove that at trial, we don't need to talk about contravention at all. When you come to causation, it seems the tribunal was thinking, you're going to have to show how this would have made a difference to the price control. To do that, you'll have to look at this price control. And so the price control is integral to your case in that way. And then it drew the conclusion that therefore you're relying on contravention and the ouster clause. That is where we say they stubbed their toe. Paragraphs 45 to 48, if I may continue, are concerned with a discussion of the Marchit case. And the purpose of the tribunal now looking at Marchit is to isolate what the Supreme Court considered to be the essential problem there, which meant that a private claim for nuisance was excluded in Marchit. And then you come to paragraph 49 of the judgment, where the tribunal suggests that similar reasoning can be applied to the damages claim in our case. And so we also focus on this and say the tribunal's reasoning is flawed. And this enables me now to consider that the point that my ladyship opened earlier on. In paragraph 48, if you look 6 lines down or so, the tribunal identifies the key point in Marchit as it was explained by the Supreme Court in Manchester Ship Canal, paragraph 105. And this is that, but Mr. Marchit had no independent basis of a claim in nuisance without invoking the defendant's obligation to construct a new sewer, and this failure was accordingly an essential ingredient of the claim. That's therefore how the tribunal perceives it, and if I may, in the remaining time before the short adjournment, then go back to the Supreme Court in Authorities Bundle 3, tab 14, and look at paragraph 105.
It's really 90, isn't it?
I'm sorry?
It's really paragraph 90, and then it's explained in meticulous detail at 105.
My lord, you're right. In the interest of speed, I will turn to perhaps paragraph 90, but if I may, I'll start with 105 and see if something needs to be added. 105 is the one that begins. As we've explained, this is a misreading of Marchit. And then they give their reasons why the court below had misunderstood the Marchit case. And if you read it from letter E, if I may invite you just to look down to letter E. Under an ordinary case in nuisance, the cause of action therefore included as an essential ingredient of the claim the defendant's breach of its obligation to construct a new sewer. Contrary therefore to the Court of Appeals interpretation of the case in the present proceedings, Mr. Marchit's claim that Thames should have built more sewers was an essential component of the complaint in legal terms. His claim was dismissed because the duty to build more sewers arose only under Section 94(1) of the 1991 Act, could be enforced only, or could only be enforced by proceedings under Section 18. Accordingly, the problem with the claim was not merely Thames's special position as a sewerage undertaker, or that in some broad sense it would undermine the statutory scheme applicable to the enforcement of sewerage undertakers' duties in relation to sewage, but specifically that it was based on the contravention of a statutory duty for which Section 18 of the Act provided an exclusive remedy. The difficulty wasn't that contravention was an underlying cause of the nuisance, but it was an essential ingredient of the cause of action for which there was no independent basis at common law. So in short, as we read this, the point that the Supreme Court is resting on is that in Marchit, the claim is based on breach of duty where there's no independent basis at common law. It's a contravention derived purely from the Water Industry Act, for which Section 18 provides an exclusive remedy. And the contrast is with the present claim, as the tribunal finds in our favour, back at paragraph 40, as my ladyship referred, this claim is based on facts giving rise to an independent duty arising under the competition laws. My lord, should we look at the other paragraph that you mentioned?
Well, it just says the same thing.
Okay, I'll leave it there. So now if we return to the judgment, paragraph 49, the tribunal is seeking to draw an analogy between marchage, as it's explained by the Supreme Court, and the present claim, 49. And if you pick it up in the second sentence, 3 lines down, you have this. The claims do not advance any separate allegation of unfair pricing that could be assessed on an independent basis to the price control regime. See paragraph 44 above. That was the United Brands point. The alleged failure by the defendants to provide accurate information occurred in the context of that price control regime, the operation of which determines the extent of any overcharge and therefore the damages incurred. Damages are an essential element of the cause of action. So pausing there, that's an observation that the allegations of abuse by misleading Ofwat and the Environment Agency, those occur in the context of the price control regime. And that is, of course, right. The error, we say, is in the next sentence, which purports to draw a conclusion from this premise, and which begins with the word accordingly, 2 lines up from the bottom. Accordingly, without contravention of the regime for determining price control, the PCMs would have no independent basis for their claims for damages. And we say that the conclusion doesn't follow because under the competition law claim, the making of the misleading representations, which we would establish in the way I've outlined, gives rise to an independent cause of action. Professor Roberts does not have to establish in court contravention of the conditions of appointment. She can prove the entire case from beginning to end by referring in that context to the misreporting and to the impact on the price control. Now, the last element of this reasoning is paragraph 50 of the judgment, and that is where the tribunal says it doesn't need to consider the issue of underreporting to the Environment Agency. And I'm conscious that, my lord, you said you regard this at the moment as a bit of a digression.
Well, not in this context,
No.
in the earlier context.
I see.
In the sentence you just read, accordingly without contravention, presumably you would say that would be sensibly fine if it said accordingly without operation of the regime.
Yes. Yeah, yes, absolutely. Yes. And that follows from the gist of the earlier paragraphs where, as I say, it appears that what the tribunal was exercised by was that this concerns the operation of the price control regime. In paragraph 50, the tribunal says it doesn't need to consider the issue of underreporting to the Environment Agency. It's important to look at this because this is because of it having focused on the causation issue in the case and Ofwat's machinery for its price control. It summarises the position correctly in the opening lines of paragraph 50. There was self-reporting of pollution incidents to the Environment Agency. The agency does use those reports in supplying information to Ofwat, but as the judgment rightly says, there was no requirement, legal requirement, to make those reports to the agency as a condition of the undertaker's Water Industry Act appointments. But the tribunal says that that doesn't matter because it describes the relevant contravention, that's the key word for section 18.8, as being in broad terms a failure to supply accurate information for the statutory regime of price control. And it concludes in the last sentence, that results from the level of pollution incidents reported to the agency, and from there indirectly to Ofwat, as much as those reported directly to Ofwat. However, the failure to supply accurate information for the price control, it's another way, the supplying of misleading or underreported information, that is a factual matter, and that engages the breach of duty under competition law. It's correct that the supply of misleading information to the agency as well as Ofwat causes the loss to consumers, because Ofwat takes that information in its workings. But to use the language of section 18.8 directly here, the damages claim does not rely on any act or omission by virtue of its constituting a contravention of the conditions of appointment when we are looking, and this is in any event, when we are looking at what information is provided to the Environment Agency. Before the short adjournment, if I may, the final point in this section is paragraph 51. The tribunal adds that it would feel concerned if its reasoning and conclusions meant that residential customers overcharged for their water supply would be left without any prospect of compensation or reimbursement. And then it records that Ofwat told the tribunal in the hearing, footnote, contrary to its written statement, that Ofwat considers it has the power through an enforcement order to direct a sewerage undertaker in breach of condition to reimburse customers the amount of the overcharge. And Mr. Hoskins said his clients accepted that Ofwat has that power. Now, I leave aside the observation, but can show you the transcript if needs be, that Mr. Hoskins' confirmation was substantially caveated as being dependent on matters such as the particular circumstances of the case and the nature of the enforcement order proposed. So it wasn't a pure acceptance that it applies in this case. That is where...
You've shown us the letter.
I've shown you what we explored with Ofwat subsequent to the hearing. And you've seen what Ofwat says. It says, ultimately, when we said, does this apply to spent matters, that's hypothetical, and they take no position in this case. So, my Lord, with that, the only remaining thing I was going to do was very briefly, not in detail, go through the respondent's notice points. In view of the time, shall I up stumps down and deal with that after lunch, or would you like me to?
No, why don't you deal with that after lunch? It's a bit of a freestanding point. Okay, 2 o'clock.
Please sit down, Dave.